like Fervent's brilliant. Like, this shit is fucking hilarious.
Kelly Reed giving a nice shout out to Fervent here. You have great videos, she says. Absolutely. Fervent's got great videos. Follow him on Twitter.
Think you're better than me? Well, why don't we see?
We lost.
That's a friggin' banger, right? Fervent, can I was like, woohoo, that is so good.
Now, you are amazing. Thank you. I love your parody videos. Keep them going. If you do that for every trial, honestly, I think we need comic relief.
If you go to Fervent on Twitter,
Fervent. Yeah, go to Fervent.
Get a different screen open, put in your Twitter, go to Fervent, and then just
right there. You don't have my Twitter hooked up to the computer.
Fervent.
Fervent?
Yes. Fervent HOSP, if that's the app thing.
Oh, Fervent what?
HOSP. But probably hospital, I don't know.
Or whoever put that together, all kidding aside, that's very humbling in a funny way.
Right.
I appreciate that.
Can you at some point explain what Fervent Hosp means? Is it like hospice care? Is it a hospital? Are you a hospitality group? Are you hospitable? Long to dying cold? What is hosp? What is fervent? What is life?
Another Karen Reed civil hearing in Plymouth Superior. We'll see if Plymouth is far enough away from Dedham to escape the stench of Morrissey's corrupt ass. Karen rocking the lighter hair color. Jackson dusts off the dried blood of Hank Brennan from his suit jacket. We wait a preposterously long time for the public to be allowed in. Judge Gildia takes the bench and in classic Massachusetts fashion, immediately calls for a sidebar. We're at sidebar for almost 40 minutes, or what we call in the biz, a full cannoni. After the sidebar, the judge says, I'm not getting paid enough for this shit. You all try to figure it out yourselves. Jackson sends a text to Diller that reads, you coming here? With 3 question marks as they meet out in the lobby. Christina Reck shows up 40 minutes late and promptly greets the O'Keefes. We stare at a ceiling without a fan for what feels like 2 hours before the lawyers return. Finally, we get to hear the attorneys speak. Just kidding. It's another sidebar. Finally, Diller gets up and says this.
I also want to acknowledge to this court and to Miss Reed that I was mistaken when I interpreted her words to say, I'm dead, I'm effing dead. Thank you.
AJ took on the role of a strict father and basically told Diller, you go out there and apologize to your sister or I'm taking your Xbox away. Diller withdraws his motion for the TRO. The O'Keefes are in shambles. Meanwhile, Team Reed is starting to take depositions in 10 days, which means expect to see a lot of friends and family meetings from the McCaves and Alberts in the next week as they review their timelines, get their story straight, and destroy whatever phones they deem necessary. What's up, everyone? Happy Saturday. Spring is almost here. Deposition season is approaching. What a time to be alive. Today, we're going to look back at the pretrial hearings from late February and March of 2024. These were the first hearings after the feds handed over 3,000 pages of materials to the defense and the Commonwealth. So all of this info you hear talked about in these hearings were brand new information to the public at the time. Before we start, here's a funny video of Lally showing up late to a hearing and staying standing for no particular reason.
Okay. Oh, all right. So here comes Mr. Lally. Were you expecting him, Ms. McLaughlin?
Yes, Your Honor.
All right. I'm sorry. I would not have started. All right. So, Mr. Lally, if you just say your name for FTR to
Yes,
get
sure.
up.
I'm Lally for the Commonwealth.
Okay. So when we were all last in court on February 15th, there was obviously Mr. Lally, why don't you have a seat? a joint motion to continue.
Now let's take a look at the top 3 comments of our caption contest. Just a reminder, this was the lovely image that I challenged you to caption. So let's see what you guys came up with. At number 3, it's Midwest Granny who says, "Look, I just brushed my teeth before I spoke to the feds." We do have confirmation that she does that. She's a great multitasker. She's able to brush her teeth and call everybody in her favorites in under 10 minutes. At number 2, Elizabeth says, "I wouldn't leave my friend that I loved out in the cold to die." Yes, that was from her dramatic, rehearsed speech when she was being confronted with her Google search in the Celebrite report. That, of course, was one of the many reports regarding Miss McCabe that was incorrect. And at number 1, it's Age of Nefarious with "I bid 'em, I bid 'em, I bid 'em." Congratulations. Someone gift her a membership, please. She's earned it. Speaking of membership, shout out to all of our new members. Our memberships just went live last week. Grab yours now because we're going to start putting out members-only content real soon that I think you're all going to love. In the meantime, like, comment, subscribe, Venmo in the top corner if you want to buy me a cup of coffee this morning. Now, let's get into it.
It says you received the information from the U.S. Attorney's Office on February 21st, and I know you outline in your motion that it's very voluminous.
That's correct.
All right.
The evening of the 21st, we basically have had access to it starting on the 22nd until today. We received 3,074 pages, 1.3 gigabytes of data. We've only had a chance to go through a smattering of that data so far, right?
Okay.
So a couple of transcripts, we've reviewed and looked at or put our eyeballs on the files, but not the substantive data contained within those files. And I would dare say that the Commonwealth is in the exact same position. There has been an additional TUI request by the Commonwealth that the court is probably not aware of. That came in on Friday. Ms. McLaughlin asked the U.S. Attorney's Office, pursuant to TUI, which is exactly the same protocol that we utilized to get these almost 3,100 pages of data. And so we're expecting that to be heard at some point through the U.S. Attorney's system. In other words, they're going to have to go to the magistrate, deal with the TUI system the same way that it took place here. And that takes not days, but weeks, I expect. We also haven't finished the Bodhi protocol, which is the state's protocol with the crime lab that you're well aware of. I say that to say, through 2 years of litigation with the Commonwealth, just about 2 years of litigation, we've received a little over 3,200 pages of data. In one day, the defense was given 3,100 pages of data, and none of it appears to be duplicative. All of it is brand new, and all of it, Your Honor, appears to us to be exculpatory. The schedule that the court has suggested, although I'm mindful of moving this along, I can't do it in violation of my client's due process rights. I can tell the court there is no possible way that we'll be ready for, just to grab my notes, there will be no possible way that we could have all of our motions written on this issue alone, just the motion to dismiss, by March 6th. It's just too big.
What I need you to do is put in writing why.
Sure. Sure.
Right?
I can tell.
I am very mindful, though, where the U.S. Attorney says we expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings. So put something in writing, get it to me by this time next week as to why you cannot be ready specifically. But I'd urge you to use that time getting ready. All right?
May I have just a moment to confer with
Yes.
counsel? I want to make sure that the court understands that in addition to, and that's what Mr. Yannetti was just urging me to bring to the court's attention. I don't want to speak for him. He can speak for himself. There is a motion to disqualify, which is also robust in scope and terms. He's going to be arguing that. That is yet to be on calendar, and he just indicated to me he does not believe there's any way that he could be ready on this briefing schedule for this kind of influx and incorporation of this level of data.
So
there's
you
going to be.
can put that in writing as well, Mr. Yannetti.
That's fine. I just want to do that. I just.
If I may, had the opportunity to go through all the discovery that's been provided. It is voluminous. It is, there's a lot of material there. However, the Commonwealth would dispute counsel's representation that the material is new information. I would say approximately 90% to 95% of the material that we've received is consistent with the Commonwealth's theory of the case and the testimony that went to the grand jury of witnesses' statements. There is some new information that counsel will use in their motion, and the Commonwealth understands that. However, I would say the evidence as a whole is very consistent with prior statements made by witnesses that testified for the Commonwealth. Thank you.
All right. All right. So put it in an affidavit by next Monday, but these days, as of now, these are our dates. So I've read everything. I'm going to give each side 10 minutes.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah, all day. But that was when we had all the motions. But it's just these two motions
right,
today.
but they're big.
They're big.
Consistent with.
Why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that.
Right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence, that's where we start, any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I will, again, I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything, and same in your supplement.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship, and I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He had been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was, quote unquote, deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam, all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E attached to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages but from the feds revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So, yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words. Because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift. Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm gonna go write a report, I'm gonna turn it over to Mr. Lally, and Mr. Lally's gonna turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife, it'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024, now let's fast forward 2 years later, now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA, under very intense questioning, that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Buchnick, all of this before Yuri Buchnick testified at the grand jury and before he and Buchnick actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Buchnick testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Buchnick knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Buchnick, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could implore the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go ahead.
Thank you. Evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert. When that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion in front of the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust. The ones that are supposed to protect our interests, and the law does not allow this sort of conduct to go unchecked. When the remedy when this sort of travesty of justice occurs is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance, I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right.
And thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card Monte trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for 2 no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided child care in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate, but I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially, what we have is Yes, what counsel mentions is there is one expert who was given 2 extractions, presumably provided by defense counsel, that indicate from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Celebrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Celebrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of that, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that.
And with regard to the 2:27 a.m. search, it's not a 3-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember, what they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. It's always interesting to hear an argument that suggests there's nothing to see here. And that's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. It doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop. That's their independent expert. Not ours. Not somebody on our payroll, like Mr. Whiffen, or one of their experts, or Trooper Garino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally, that car did not hit John O'Keefe, and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these two texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were, in fact, in communication with each other as early as 2020. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it and deny this motion. We're talking about the integrity of what is the foundation of Massachusetts' judicial system. And that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right.
There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. So for those reasons, in some ways, it pains me to have to file a motion like this. But D.A. Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand.
The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
So the question then becomes, why did he do this? Why did he take such a personal interest in this case such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting, they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, D.A. Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury. Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you. Indeed, Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Read convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Read is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time.
Well, it's kind of like a butt dial. I butt dial people often.
I believe I used the word butt dials. I used a phrase that people commonly used as a butt dial.
So you think it's possible that you may have butt dialed Brian Albert for a 22-second call that you're not aware of?
There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth.
The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case.
The Fervent investigative team is here to get one question answered. What is witness intimidation? It's not just about silence. It's about control.
We were granted access to a police interview regarding real witness intimidation. The results were unnerving.
What happened? He made faces at my window.
Were you here when it happened?
No, we were closed, but I was so scared.
What did they leave for you?
That.
A rubber duck?
It's terrifying.
Call me when you want to be serious.
Hey, Chris!
Ah! Stop it! You're intimidating me!
Intimidating? We're all 65 years old.
Which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth, nothing was asked for from the district attorney's office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous. Disingenuous would be about the nicest term that I can come up with for that. Thank you.
All right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton police officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that They were conflicted out.
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that, Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the self-recusal of the Canton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, Nobody can claim that anymore with a straight face.
Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Isn't it true that you were, in fact, ordered to preserve your cell phone by the Commonwealth?
At some point, I was made aware of that, yes.
All right, let's just get to the brass tacks. Where's your phone?
My phone was upgraded and traded in for a new phone.
Your phone was upgraded and traded in for a new phone?
Yes.
Okay. Another way to say that is you traded your phone in and got rid of it, correct?
I traded my phone and upgraded it, yes.
When did you get rid of your phone ending in 0888?
I upgraded my phone in September, third week of September, maybe around 22nd.
The 22nd of September?
I believe so. I can't be sure of the exact date.
So, according to you, you got rid of the phone that was the subject of a court order preservation the day before it was ordered preserved, right?
Rephrase the question, please?
I've represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a Congressional Medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide.
You were aware that there was a court order that you not alter, delete, or destroy, or in any way manipulate your phone or the electronic data associated with it, correct?
Objection.
As to what date?
As of September 30th, 2022.
Objection. I don't believe that's what the court order was. I think it's
I can make a quick offer of proof. That's exactly what it was that he was notified.
Were you aware of that? Was that your understanding?
What's the question exactly, Your Honor? I'm sorry.
Ask the question again.
Sure. Were you served with a copy of a notice on September 30th, 2022, that you not alter or destroy or manipulate anything on your phone on September 30th?
I was served an order, yes, that's correct.
Okay. And isn't it true, in another hearing, you explained that on September 29th, the day before you claimed you got that notice, you changed phone carriers and changed phone numbers?
And I maintained the phone.
Until you didn't, when you destroyed it a month later by pulling the SIM card out and throwing it away, correct?
Objection.
Sustained.
Then you drove to a military base and you threw both the destroyed SIM card and the phone into a dumpster, did you not?
Well, I was cutting through the base, and I believe how I testified
Did you drive to a military base, sir?
I was cutting through a base, yes.
Did you drive to it?
Yes, sir.
And then you put both the destroyed SIM card and the phone itself which were in a trash bag, into a dumpster on that military base, did you not?
Believe that's what I did, yes.
And he said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them, and I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed, and it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately. United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call from or with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute, then another call with Albert for 10 minutes, then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th, after that lawn had been searched by trained investigators and other police officers multiple times without finding it. But somehow, Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful.
All right, we're going to stop it there for today. Thank you guys so much for spending your Saturday morning with me. And for those on replay crew, that was just a refresher of what the first few pretrial hearings were like following the federal disclosure. And if you notice, the defense never even brought up Michael Proctor's text. That didn't come out until Yannetti's opening statement in the first trial. So it's always fascinating just to go back and revisit these pretrial hearings and realize that we're still doing this 4 years later. Guys, it's very easy to forget to hit like on a video. I'm guilty of it as well, but it does really help us out in the algorithm. So if you could do your boy a favor and smash that like button. All right, what should we play on the way out? You know what? We're going to play my newest single. It's called Pirouette Boy, from the perspective of Trooper Joseph Ball. Have a great weekend, everybody.
Put your arm out to the side, do a little spinning. Do the pirouette boy, the pirouette boy, the pirouette boy. Put your arm out to the side and pirouette boy, pirouette boy, pirouette boy. Put your arm out to the side. They say it came from a tail light. I say I don't know, that look like a dog bite. They tell me Paul, look the other way. Is this the first person that you frame? So I start by talking to the crime scene. And yes, I mean the actual crime scene. Lawyers asking where the body and debris. I say I can't say definitely. Jackson asked me questions and I'm supposed to feel. He wanna know how John O'Kee got hit. So I tell him, Paul, put your arm out to the side, do a little spin that. And do the pirouette boy, the pirouette boy, the pirouette boy. Put your arm out to the side and pirouette boy. Put your arm out to the side.
Damn, Fervent go crazy on that beat.
What about this piece of debris? I say, I guess he must have flown 30 feet. Wanna grill me about my degree. Go talk to one in Shannon and get back to me. Mr. Jackson, here's the situation. I don't know anything about these calculations. Yeah, I know you used to work in aviation, but these physics terms got me hyperventilating. Jackson asked me questions and I'm supposed to feel. He wanna know how the evidence got where it did. I say I got the physics knowledge of a kid. My only explanation is it just did. Pirouette boy, pirouette boy, pirouette boy. Put your arm out to the side.